Namaskar, my name is Raman Narayan Upadhyay. In this video lecture, I am going to discuss about sources of law. Friends, before we discuss about the sources of law, it is important to know what law is. Generally, when we speak about law, something strikes in our mind that perhaps it is a different kind of concept which is alien to us, but it is not like that. I will explain to you when I will speak on the different sources of law. But as far as definition of law is concerned, it is meant to have rules or regulations, bylaws, etc. to regulate the behavior of the people and to establish relation between people and the state. Here, between people to people, between people to state, and between state to state, it is state means here I am talking about in a federal form of government where there are a number of state governments. Otherwise, when we speak about the state in international context, it is coming like one of the nation, municipal nation. So here, friends, law is uh, actually identifies by its effect. A law may be sanction law, a law may be a rewarding law, a law may be negotiating law, a law may be compromising law. All these things could be attributes of law. Here, precise definition of law is very difficult to find in any statute, but under Indian Constitution, some examples of law have been given. It is under Article 13, Clause 3, Subclause 3. It runs as law includes ordinance, order, bylaws, rules, regulations, notifications, custom or uses having the force of law. Very interesting fact is here. Our Indian Constitution does recognize custom as a source of law. So, friends, let us turn towards some theories. Someone has tried to prefer two main sources of law. One is material source, other is formal source. To material source, he further subdivides it into legal sources and historical sources. Material sources, he says that the law derives its a matter and not its validity, means it is somewhat related to the substances, the facts, the observance which was already existent in the society. Law derives matter of its text from the material sources. For formal sources, it says that these are the rules of law, these are the sources from where the rules, regulations, laws, bylaws, all these different types of the forms of the law derive its validity. Thus, the will of a state as manifested in the statute book or decisions of courts are the formal sources for summons. While legislation, custom, agreement, and professional option, abuse, etc. are the material sources of law. It is sometimes seen that in court's decision, few references have been made to some legal scholar on a particular point of law, and the judicial decisions are taking shape accordingly. To kitchen, the sources of law can be classified broadly into two categories. One is binding source of law, other is persuasive source of law. He says that the binding source of law again has three classes. One is legislation, second is judicial precedent, and the third is customary law. What persuasive source of law is? Those sources of law which are those laws which are not codified but existing in the society, existing in the good conscience of the people, that is principle of equity, professional opinion, judicial writings. So this is something about the sources of law. So here uh, in every legal system, even today, we have three sources of law, that is legislation, it is at topmost. Second is judicial precedent, though it's a secondary, nonetheless it is sometimes prevalent over the legislation too. And last is the customary law. It is surprising to listen that in a democratic form of government or in any democratic country, the custom may prevail, but it prevails. I will explain in our next video. Thank you very much.